I'm Colin Singer, immigration lawyer and managing partner of Immigration.ca. Mobility of permanent residents under provincial immigration programs. The right to legislate in the field of immigration in Canada is shared equally between the federal government and the provinces. Since the Quebec government acquired exclusive rights to establish its own immigration policies and programs in 1981, all of the provinces and territories have implemented their own immigration programs to select immigrants. But what is the implication when a province issues an approval for an immigrant to relocate to its province, and what are the obligations of an individual to actually settle in that province? Increasing numbers of applicants are applying for admission to Canada under a provincial nomination program, or a PNP, or through the province of Quebec. A starting point for discussion is Section 6 of the Canadian Charter of Rights and Freedoms. Commonly known as the Canadian Charter or the Constitution Act 1982, it is a series of legislative enactments dating back to the birth of Canada in 1867. It provides Canadians with basic rights in relations with government at all levels and binds all provincial and territorial legislative assemblies in Canada, including the federal legislature or the Parliament of Canada. Section 6 provides permanent residents and Canadian citizens with the right to live and work in any province in Canada. Section 6 reads, 1. Every citizen of Canada has the right to enter, remain in, and leave Canada. And subparagraph 2, every citizen of Canada and every person who has the status of a permanent resident of Canada has the right to move and take up residence in any province and pursue the gaining of a livelihood in any province. In immigration matters, the implication of Section 6 and mobility rights under the Charter is significant, but these rights do not actually begin until permanent residence has been established. Once a province selects an applicant, the Federal Department of Citizenship and Immigration will oversee admissibility issues, including health and security. Upon landing at a port of entry in Canada, the Canada Border Services Agency will also ensure admissibility, and this would include verifying the truthfulness of an applicant's intentions to reside in a particular province. Paragraph 87(2)(b) of the Immigration Protection Regulations clarifies that a foreign national is a member of the provincial nominee class if they intend to reside in the province that has nominated them. After receiving a permanent residence visa and appearing at a port of entry for admission to Canada, once admitted, there is nothing that can come in between an applicant's charter mobility rights to live and work anywhere in Canada. The provinces which seek to attract newcomers under their provincial immigration programs are left to create the right conditions to attract and, more importantly, retain immigrants. This has been an ongoing challenge for some of the provinces that are being used by applicants as a backdoor entry to Canada and who do not otherwise qualify for admission under the Federal Skilled Worker Program. Indeed, this has been a serious challenge for Quebec, which has direct authority to select some 50,000 newcomers each year under all categories, representing 20% of total admissions to Canada. This is by far the most of any province. Historically, and as empirical data confirms, the province of Quebec retains only a fraction of the applicants it actually approves. Many applicants often decide to forego their initial intention to settle in Quebec and elect to settle elsewhere. This is especially the case under Quebec's Immigrant Investor Program, which has dominated the Canadian market of investment-based immigration. For other provinces, including British Columbia, Alberta, Manitoba, Saskatchewan, Nova Scotia, and Prince Edward Island, which promote their own skilled worker programs, the retention of immigrants remains an ongoing challenge for policy makers. Applicants applying through a provincial nominee program must be mindful of the requirement to maintain compliance with the program and truthfulness in the entire application process. The intention to settle in a province under an immigration program must be clearly present upon landing. In the case of individuals where indicators are at the port of entry that they are no longer intending to reside in the nominating province, they may be reported under Section 44 of the Immigration Act for non-compliance with paragraph 87(2)(b) of the regulations. At worst, where it becomes evident that an individual never intended to reside in the nominating province, this could give rise to an allegation of misrepresentation under Section 40 of the Immigration Act. Canada's 730-day residence rules are among the world's most flexible. Applicants can theoretically leave Canada soon after becoming permanent residents for a period of up to 3 years, while retaining their Canadian permanent resident status during an initially long period of absence. A Canadian permanent resident is thus afforded the protection under Section 6 of the Charter to change their minds about where they want to live and work in Canada. There are no obstacles or formalities for Canadians to change their province of residence once permanent residence has been firmly established. Government immigration officials at the federal and provincial levels are well aware of this dilemma. Given the unpredictability that exists under the current federal express entry system, provincial immigration programs will increasingly become attractive entry points for newcomers to Canada. The provinces also face increasing challenges to correctly choose and retain immigrants. Applicants considering an immigration project to Canada under provincial programs must do so while carefully balancing their legal rights afforded by Section 6 of the Charter and the legal obligations imposed under the Immigration Act.